is a brief demonstration of the SCOTUS mapping software. This software is a tool that enables users to visualize the development of SCOTUS doctrine. To demonstrate it, I'm going to show you today the origins of Justice Kennedy's majority opinion in United States versus Windsor. Of course, that was the case that was just handed down at the end of last term that struck down DOMA as violative of the Fifth Amendment. Some commentators have complained it's not exactly clear whether it was struck down on equal protection grounds or substantive due process grounds, and I'm going to show, using this software, how it really is both and how that's quite legitimate, at least defensible in terms of prior precedent. Let me start by starting the slideshow. Once the slideshow goes, you see the basic axis. The y-axis is the number of votes an opinion receives, and the x-axis is the year that the opinion is handed down. The first opinion in the line is Windsor. Of course, it is citing prior opinions, and Windsor was a Kennedy decision, 5 votes, and unsurprisingly, he cited back to a very important prior Kennedy decision that had 5 votes, which was Lawrence. Lawrence struck down the ban on same-sex sodomy in Texas, and I've called this a affirming same-sex rights decision. It was explicitly a decision that had to deal with gays and lesbians. Other decisions, as we'll see, didn't explicitly deal with that. But another one that did was Romer. Romer was another Kennedy decision, got 6 votes. It struck down Colorado Amendment 2, which purported to take away special privileges from gays and lesbians, although the majority found that it actually did a special burden and thus violated equal protection. Lawrence itself cited to Romer. So Romer was an equal protection case, quite explicitly, and it arose out of a series of prior equal protection cases, which I will go through quite quickly. There's Moreno, a 1973 Brennan decision that struck down a portion of the Food Stamps Act that denied people who were not in the same family from claiming food stamps benefits if they lived together. The law was seen as created out of a special animus for actually hippies, and it was a type of rational basis review, although not explicit. It wasn't about protected classes as much of equal protection jurisprudence is. Moreno, in turn, relied on a prior Brennan opinion, Eisenstadt, which was a 1972 decision that extended to unmarried couples the benefits of contraception, which had been allowed to married couples in a case called Griswold, a 1965 opinion. Eisenstadt was an equal protection opinion, whereas Griswold was essentially a substantive due process opinion. You'll see that same kind of movement in Romer, which was an equal protection opinion, that the inverse, Lawrence, which was a substantive due process case. Anyway, Eisenstadt also cited back to Loving, which was a 1967 case striking down Virginia's laws against interracial marriage, and that in turn relied on a 1942 Douglas decision, Skinner, which struck down a law in Oklahoma which provided vasectomies as a form of punishment, but only for people that were convicted of crimes basically that poor people did. That all goes back to the equal protection component of either the 5th or 14th Amendment. The other line of cases is the substantive due process line of cases. Lawrence, in turn, cited back to both Bowers, the dissent in that case, the majority in Bowers had upheld a ban on same-sex sodomy. Blackmun's dissent was one that Kennedy explicitly cited to, and he also cited to the substantive due process case Casey, which upheld the woman's right to choose an abortion, which came from Roe v. Wade, the infamous or famous 1973 Blackmun decision. Of course, Blackmun, in dissent in Bowers, had cited back to his own opinion in Roe as talking about the kind of liberty that he was talking about. Roe, in turn, also cited back to the important Griswold case, as well as the very early Pierce versus Society Sisters of the Holy Names of Jesus and Mary, one of the very earliest substantive due process cases going all the way back to 1925 that essentially affirmed the rights of parents to bring up their children the way they wanted to. Griswold, of course, relied on that case as well, and Pierce goes back to the 5th and 14th Amendment. Now, I've gone through this very quickly. Hopefully, the professors out there can realize how this software can be used to structure a discussion about these cases and these different lines of equal protection and substantive due process, and how they all laid up in some way to the Windsor decision striking down DOMA. And that is the end of the slideshow and the end of this little demonstration.